Uday, the floor is entirely yours. Please go ahead.
Namaskar. There are 4 speakers and a moderator. The time allotted is about 90 minutes. We started around 15 minutes late, so therefore I asked the moderator how much time I have. He gracefully said 10-12-15 minutes. So I am taking a link, I am taking a clue, and I am starting immediately. Since morning we have heard so many things. We have been educated. But now therefore let us start with some short stories. Tomorrow there is a matter, of course it is beyond the reaching zone. In Bombay High Court there is a reaching zone depending on the capacity of the Honorable Judge. The item number is 70, but the issue is very important. He is a small shopkeeper who is having a one grocery shop near my place of residence at Prabhadevi, Mumbai. One evening he came in my office at Fort Mumbai. He said that, sir, this is my original Aadhaar card, original PAN card. I have received a notice from some advocate who is stationed at Ahmedabad and that is in Gujarati. Please explain this. So I called my one of the learned junior who understands Gujarati language. He immediately translated that and he explained that no, there is a check which was given by him and that check got dishonored in Ahmedabad, so he has received notice. So I asked this gentleman, small grocery shop person, have you issued any such check? He said no. Then have you opened the account in this name? He said no. Have you ever been to Ahmedabad? He said no. Do you know any of them? No. Then I said that no, but it's a notice, so we will respond to that. So we prepared a reply saying that everything is denied. Unfortunately, he was shown as an accused in a 138 negotiable instrument case filed at Ahmedabad. Slowly we started receiving a notice of another advocate saying that you have entered into a live-in license. This is your account details. These are the details. We have paid the amount. Now please return please pay the balance amount. So I asked again him, what are you doing? He said, sir, I am sitting almost 12 hours, 15 hours in a shop which is next to your housing complex. How can I go there? How can I open? And then slowly we started realizing that this is another victim of sharing of those details which he might have shared unintentionally. So we filed a petition in the High Court. And that Aadhaar authorities are joined as a party and the request is, please restore my identity. It is going to happen. This is the future. This is the future. The simple request is, please restore my identity. This is that problem which we are likely to face in the near future. So let us start with another example. This is prior to the bill which our friend Rajiv made a reference and the amendment. One student of law from ILS Law College, Pune, she came with a reference of one senior advocate. She said that, sir, long back I had one traffic accident with a car which was owned by son of a minister. And I was dragged, I was shown as an accused, I am fighting that litigation. But incidentally, when I went to that particular police station, I found that my photograph is displayed on the notice board of that police station. So we filed a petition ultimately saying that how can you do this? Police authorities were justifying, they filed an affidavit. Bombay Police Manual, which is a compilation of all executive directions that permit them to maintain the record and display the photographs of the criminals. Ultimately we were required to come in the court and we got an order. So therefore now that lady advocate is happy, her dignity is restored, her privacy is also protected, and she got married and thereafter she started her independent practice, she is doing good. This is also likely to happen about this aspect in the near future. The organizers wisely selected this topic. The topic is governance, data governance under the Act, criminal law and privacy. We have heard substantial about the provisions of the Act, but nonetheless, some reference to the data governance will be required because my earlier speaker has left that for me. The data governance ultimately contemplate, you are aware that different policies are covered under this Act, section 22 to 28. Those who are not Act, the bill, those who are interested, they may note down. Then there is a transparency accountability measures, section 29 to 39 proposed in that bill. You will find that organizational structure is also there, namely Data Protection Authority, in respect of which section 49 to 68 is also there. You will find appellate tribunal, section 79 to 89, which deals with that provision. You will find that about processing of the data, the provisions in the section 4, section 7, section 12 to 22, these are already provided under the bill. You will find about the offences and the penalties. You will find section 69 to 78 is a group which refers to the penalties, the offences under section 90 to 96 which are already provided. Then about the quality of the data, section 9 is there. So then about the cross border, which our friend made a reference, and the earlier speakers in the earlier working sessions have a reference, section 40, 41 are there in the bill, and then the explanation is there under section 42 and 44 which have been proposed, 42 to 44. Having said about this basic thing which is available in the material which has been provided by the Bar Association of India, now let us come back to the basic scheme with reference to the offences, because the organizers want that now the another topic is required to be highlighted, that is with reference to criminal law and privacy. Ultimately, what is a problem? What is that particular offence which is as on today provided within the framework of Indian Penal Code with reference to the data protection? Take a case that there is no Information Technology Act. Then what kind of offence is possible? Trespass. Trespass, you are having your own valuable information, the person is trespassing and he is committing some offence. It is possible that negligence, the person to whom you have given certain information and he is neglecting, he is not discharging his duties and he is sharing that information. There may be other few types of such basic offences within the framework of the Indian Penal Code. When the Information Technology Act came in the year 2000 and then 2008 amendment, this right of privacy started coming little bit in the framework of a legislation. 66E, those who are interested, they may go to the Google Mousy. I believe you know the Google Mousy. We are slaves of this Google Mousy which is sitting inside. And I'm sure those who are ready, they will ask immediately the question to that Mousy. She will give a reply immediately. That is section 66E, which says about the violation of a privacy, then the three years punishment, imprisonment is there. Then the 2008 amendment, which you will find that section 43A is also there, which says that there will be a compensation which can be awarded for failure to protect the data. So therefore I said that slowly the concept of data protection started coming in, and then section 72A comes, which says that the punishment for disclosure of the information in breach of the contract, where 3 years or 5 lakh rupee fine or both have been provided by the legislature. But slowly we started realizing that this is not enough. This is not complete in itself. This is not a complete solution. And as rightly said by the earlier speaker, earlier moderator in the sense Dr. Pinky Anand, that one shoe can't fit for all. On the same line, we started realizing that the Indian Penal Code framework which was there is not sufficient. The information technology offences which are created are not sufficient, and now therefore there is a need for a further step of a legislation. We are aware as a student of law that the legislation is required to control and regulate the technology. Nobody is saying that the technology is wrong. The person who is using the technology may be a person who may commit a mistake, who may commit a wrong, who may commit an offence. So therefore now there is a need of the society with reference to a further legislation apart from the basic framework of IPC, then information technology, and the technology has developed with such a rapid speed that we need a further, which may be called as super specialty field. When the Information Technology Act came, we lawyers, we started feeling that no, that cyber law is a super specialty field. But when we are dealing with a data protection, then of course we will have to say that it is super specialty field, because now this is a need of the society where a new legislation is required. Having said about this, the problem is not yet clear in front of us, because the earlier speaker also made a reference about the cross-border issues, about the territorial issues. In the earlier session we have heard about that. These are the problems which have been considered within the framework of the new bill, but in my humble submission, it is not complete answer. It is going to raise several legal attractive issues before the court of law. There are persons who are going to challenge it, and of course they are bound to challenge, because the bill is required to be considered from different angles, and then perhaps the law will be settled. The same thing happened in Puttaswamy. It took time. It is possible that, therefore, the time which is required for framing a proper legislation can also be ignored. We are aware from 2017, for last 5 years, we are taking for finalization of the bill. We are still at the stage of an infancy of a legislation. In the form of a bill, it is just tabled. So therefore, in these circumstances, even if it has taken 5 years, let us try to make a better legislation. The moderator in the welcome speech made a reference that whether we need a law which is a bad law, instead of there should not be a law. I beg to differ, London moderator. No law is perfect. No law can be a static. The law will be developing, and of course I am sure that the Bar Association of India has taken a lead, and all of us are waiting here for this third working session. Almost 50 persons are waiting here who are contributing. So therefore, I am sure tomorrow the better legislation is going to come. Having said about this, now let me point out the other angle, because 2 more minutes are left. It is 11 minutes and 47 seconds are over. 1 or 2 minutes more, because he said maximum 15 minutes. Being a Bombay person, my clock is ticking. So therefore, I am going to conclude within 15 minutes. Let us understand, there are around 200 countries in the world, around 190 or likewise, 190 plus. How many countries are there who do not have any kind of a legislation, any kind of a policy with reference to the data protection? You will be surprised, almost 50 countries. I prepared a list of the countries which are depending on the exercise of the Indian legislators, which includes Afghanistan, which includes Bangladesh, which includes Cambodia, Fiji, Kuwait, Iraq, Iran, Oman, Maldives, Myanmar, Pakistan, Saudi, Sri Lanka. So many our neighbors. So many our neighbors are waiting for our exercise. They don't have any separate piece of a legislation. They don't have a policy. They are waiting to us with a hope that we will guide them. Now, of course, therefore, the burden on our shoulder is much more. And then again a question comes that under the framework of this act, how are you going to prove the offense? We are having an experience about the cyber offenses. Most of the offenses culminate into filing of the report where offense has taken place but the accused is not traceable. We are aware about the Nigerian fraud cases where the people have suffered harm, injury, sustained losses, but the accused is not traceable. Are we going to create, or are we going to give rise to one more type of such offenses about the data protection where we can say that the injury is caused to a person but the accused is not traceable? And now therefore perhaps the time has come to consider the Evidence Act. We are aware that the Electronic Evidence Act is also one of the method which can be used for the purpose of proving those offenses. Most of the lawyers are not trained about that. Most of the honorable judges are not sensitized about that. Despite that, day in and day out, these things are happening. Something better will be required. Despite having an electronic evidence provision, we are aware that large number of acquittals are taking place because the investigating officer is not aware about the mechanism how evidence is required to be collected. We are aware about the provisions in the Information Technology Act which says that the higher officer will be a investigating officer, but he also doesn't understand the information technology law and the electronic evidence. Then the question comes that can there be a presumption which can be created within the framework of the new legislation? Can that be whether that there can be a further option of shifting the burden on the accused to prove the offenses? These are the questions which are likely to come in in front of us in near future. Having said about this, let me comment about the 1920 Act, which Rajiv Dutta ji made a reference. We are aware that the person who has been convicted, he is under a restriction, his free movement, that right is controlled, that right is regulated, he is curtailed, he is detained at one place. Now, does that mean that all his other rights are infringed? The answer is no. The person who is shown as an accused, person who has been arrested, person who is detained, person who has been convicted, they are having other rights. And now therefore a question is going to come very soon, and as rightly said by Senior Advocate Rajiv Dutta, that nobody has challenged. Very soon this 2022 amendment is likely to be challenged. Somebody is going to challenge, and therefore this is also one of the challenge in front of us with reference to the criminal law and privacy. I am sorry, almost 40 seconds more than the time which was given to me. Thank you very much.
Thank you very much, Uday. That was a great talk, and I really appreciate your point regarding the identity theft which you started with, and that's really something which anchors the reason why we need data protection law. Our next speaker, Anita Gurumurthy, the next 15 minutes are all yours.
Thank you so much. Eid Mubarak to everybody. I'd like to connect questions of data governance with society and not really delve into the aspect of criminal law. I'm not a lawyer. I'm not trained as a lawyer. But I engage as a civil society member of an organization very deeply into questions of governance and policy. So that is my claim to legitimacy, to be here and learn from everybody. What I'm therefore going to focus on really is questions of public interest and social justice, with your permission. So to begin at the beginning, India's data governance approach has focused primarily on unlocking data as an economic resource. In fact, the questions of data governance in the country have been framed mainly as an issue of comparative advantage and trade, going back to 2019 at the Osaka summit, where the Prime Minister asserted that rulemaking on data governance in trade debates cannot undermine the sovereign right of all countries to frame rules for data that further their citizens' best interests. So if you actually look at data, there is a very, very inherent tension in data governance, which is that data implicates two very vital rights, and both would actually be natural rights in some sense, because they go back to the question of the indivisibility and integrated nature of human rights. One is the right to personhood, because data about me, as people have spoken about, you know, the very curious cases that my previous speaker spoke about, identity, personhood, these are very, very vital. So data implicates the right to personhood. But data is also a resource. So the resource governance of data is a very, very vital question, because there lies the issue of how do you govern something that belongs to everybody, right? So let's all understand one thing from a computational perspective, that data about you or data about me is not valuable in and of itself. But when data about you and data about me are connected through patterns with perhaps data about, let's say, what's really happening in the public spaces in Delhi, what's really happening to the quality of air, what's happening to the soil data, etc., which is called mixed data, right? Data which is personal data and data which is non-personal data. All of this tell a story. So essentially, what scholars are arguing is that data as a resource is a collective resource, almost like the forest, almost like natural resources, which have very, very special requirements for governance, and therefore data is not oil. So here we are, we find ourselves at this very curious point where we have to sort out this question of the right to personhood and the right to gain from the benefits of data as a resource. So every one of us has a right to gain from the benefit of data as a resource, which unfortunately today is locked up as, you know, in enclosures, in private enclosures by corporations, which was also pointed out by previous speakers. But to come back, because India really in the 21st century really wants to gain comparative advantage in the AI economy, so to speak, The whole idea is that you need mostly a low threshold harm prevention perspective involving the minimum for privacy and security. And it's not really about enhancing a rights-oriented society in the digital context. Unlike a country, a global south country like Brazil, which has a civil rights perspective on the internet, which has a constitution for digital rights. So we actually don't have a constitution for digital rights, which a country like Brazil does. So even the earlier version of the PDP bill in 2019 was intensely critiqued for providing large exemptions to government. And I think in the session in the morning, you may have visited some of these questions. But the 2021 version marks a worrying progression. And I think I will not delve into that because of redundancy issues. Unrestricted power has been provided to the union government to frame policies for the digital economy. Considering that the union government is the custodian of a large data sets, non-personal data sets, policy areas like the national agri-stack, where data is going to, previously existing legacy data sets are now going to be made open, or health data from the public health system, or data about skills, about workers, which is the eShram portal. All this data has become suddenly extremely valuable. They are valuable because there is a certain commercial value to this data, but from a civil society perspective, I would also like to submit that there is a public value, there is a social value to this data, which is above and beyond the individual value to data. So in some sense, I think the state is not an owner, which is why the utilization of the term fiduciary, the state is a custodian, and the state really is not the institution that can aggrandize to itself powers with respect to data. And we have to really look at a society of socio-economic equity and protect the civil and political rights of everybody. And I want to do one thing. Just like it was pointed out to us that it would behoove us well to think about what the writing on the wall looks like and travel a little bit, into the future. I'd like to take 5 years of the general data protection rules in the EU and see where the European Union has gotten itself tangled in, right? So you actually have a kind of a governance framework already in the EU, which is the GDPR. And there are certain lessons and insights emerging from the EU GDPR. And I'd like to place that in front of all of us so that we can learn from the complications arising in the context of the EU. It would also be important to mention here that the GDPR, of course, is the mother law. But since then, several public consultations have happened in the EU, particularly with respect to the Digital Markets Act, which is a proposal. The implementation is expected to happen in 2023, which is about governing platforms. The Data Act, which is very, very important because it's comparable to, and the parallel to the Data Act in the EU is the non-personal data governance policy, which also is not yet a law in our country. And there have been 2 public consultations, and there's a version on in the public domain. Then there is the Data Governance Act and the proposal for regulation of artificial intelligence, 2021, and the Open Data Directive. So all this comprise a family of data laws in the EU, and many of them are still being debated. What's really important is to, with respect to the Data Act, which compares to the non-personal data proposal in India, this is aimed in the EU at ensuring fairness in the allocation of value from data among actors in the data economy and to foster access to and use of data. So today, very big tech giants take away the data to process the data and come up with trade secrets or perhaps patents, and that's really the strength of the monopolistic first mover advantage, winner take all data economy. And the concern in the EU is what is really going to happen to all other enterprises, right? Many of them want to be startups. And so India also is ruminating over this very, very important question. We do not have any clear law yet on economic governance. What we do have is, as has been mentioned, the IT Rules 2021, which cover to some extent large social media intermediaries. However, the IT rules do not regulate economic activity in quite the same way as the Digital Markets Act. The Digital Markets Act really seeks to ensure more or less, at least in its intention, a level playing field for all the platforms, and it checks the kinds of data that may be mined so that privacy is protected. Now, what I really want to do is that all the proposed legislation for the economy in the EU declare very explicitly that they are complementary to the GDPR. So The mother legislation is privacy, human rights, and then of course you have the economy, which is sought to be subsidiary. But scholars have pointed out that, and that I will come to very soon enough to tell you a story, which is that today everybody, and of course we have the industry perspective, the deep, I think, search and quest in industry is, how do I make things privacy compliant and then go about my business as usual? So I just want to ensure consent in the name of informed consent, which of course means nothing. And once I can tick all the check boxes, I can go about my business as usual, which is really to find ways around, human rights questions to aggrandize wealth and power. So the JPC report gives a wide power and almost blanket exemption to the union government under clause 35. This is the unrestrained powers of the government for processing data without consent. This is the first point I'd like to put forth here. The second point, and I want to compare India's PDP bill with the European approach, which is the right of employers versus right of workers. Here I think it's really important to remember that in the context of India, the JPC report broadens the scope of the data that can be collected by the employer. Of course, employers always collect data. In fact, the bill goes to the extent of saying that any personal data, not being sensitive personal data, may be processed if such processing is necessary, which is really what is done of Swiggy workers, of Deliveroo workers, of everybody, where drivers, Ola drivers, intimate information about their leisure, what they do, when they log off, all of that is collected, and it's completely invasive. The GDPR starts from the other side. It protects the rights of workers and not the rights of employers. So it says that data is framed in relation to the worker, whereas in the GDPR in 88 Article 88(1) says, more specific rules are necessary to ensure the protection of the rights and freedoms in respect of the processing of employees' personal data in the employment context, which basically means that there is a larger framework of labor rights, and suddenly by bringing in a PDP bill and giving exemptions to employers, you cannot take away those rights. The third aspect I want to talk about is pseudonymized data, which is different from anonymized data. So pseudonymized data is just giving a stand-in. Anonymized data is you cannot trace back the individual. Anonymization is also subject to a lot of controversies because it's always possible to de-anonymize and re-identify, and that is always the risk. And therefore here, I think it must be noted and underlined that at least in the UK, as well as the Irish government, the courts have actually come in and said that anonymization is fraught with risk because of current capabilities of re-identification. Techies can simply take 1 or 2 parameters and put that against a vast data set, just a geotagged location, and re-identify every single sensitive personal information about a person or data set. That brings me logically to the next question, which is group rights on privacy. Group rights are extremely important in all contexts. Groups are communities. They may be identifiable either through their sexual preference or through their religion or through anything. And it's vital to ensure not just individual rights in society, but also group rights. And here I would really like to point out that big tech companies collect a lot of information, and the EU GDPR, which is individual-centric in its approach, has really failed group rights. In a context like the EU, which as such has a very strong tradition of human rights and labor rights, as I just pointed out, in case after case, it has been pointed out that group rights are indeed vulnerable under an individual-centric libertarian approach of the EU GDPR. So, I just want to leave that question for the Indian context in terms of group rights in our context. And fifthly and finally, what we need to understand is what I pointed out, and this is my last submission. You might even get your privacy, right? If you're very, very well informed, you can read those realms and pages, and you opt out by saying, no, I don't want advertorials, and I really don't want nudging, I don't want this personalized kind of treatment, please just leave me alone. Maybe because, you're a lawyer, you're very, very well versed with technology, etc. But what really happens here is a different situation. The infrastructural power of big tech companies over society really calls for a kind of step back to look at, are privacy rights and freedoms and confidentialities that the purpose of why we are governing data, right, for human rights? There, the unequivocal answer is no. We want a society with autonomy. We all don't want to be told what to buy. We don't want to really be told what films to watch on Netflix. We really want to exercise our authenticity as human beings, and that really leaves us with an important idea of collective freedoms, which is why an individual and a society as a structure has to be reconciled in the various ways in which agency and autonomy are awarded to the individual and structures of society are just, right? So in this context, it's really important to remember that the entire GDPR and privacy by design techniques of databases completely fall flat. They are counterproductive. And over the 5 years, many cases in the courts have really shown that this is just scratching the surface, because via privacy-friendly solutions, we see big tech incursions into our very, very intimate and private lives. And this actually is the infrastructural power. And in the health and medicine sector particularly, companies are launching really as much data capture as possible. And I'd like to give you an example of Apple and what it does. It doesn't collect your data. Just by allowing usage of its AI solution, access to your iPhone, the data is residing in your phone, but through these decentralized techniques and distributed technological solutions in computing, it just reads the data and takes it to refine its AI engine. So, I mean, you have a perfectly fine solution to your privacy, but absolutely, I think, ridiculous solution to the question of self-determination in society, right? Who is taking the decisions? I mean, it's really, therefore, very, very important to go into these lessons from the GDPR and finally, central aspects of the GDPR and its underlying data protection principles and regulatory categories. The entire notice and consent model and the narrow remit of regulation really does not at all address or addresses to a limited degree the harms and discriminations, and this calls really attention to the misalignment in certain sectors like health. Digital health, education technology or ed tech, they're all running riot. And therefore, if we really want solutions, it's not enough to give privacy, but it's important to understand how the psychology of children is being captured. And tomorrow, fintech solutions are going to run on top of Byju's. And Byju's will have a profile of the household. When did you borrow money? When did the mother go out to buy groceries? When did the father? And what does it really mean for that child to really want to borrow to do a Coursera course in class 8 to acquire certain skills? All of this seem like some dystopic reality, but we are actually living through those. And I think this throws into doubt whether the regulation that we are talking about here is fully fit for the purpose of governing current developments in the field, and technology really needs to be understood far more for the ways in which the autonomy of society is being lost. So I would really like us to pay attention to those aspects, not just the individual privacy aspects. Thank you so much.
Thank you very much, Anita. That was a whole new perspective on personhood and where we stand in all of this. And thank you for discounting privacy in the sense of there are other values as well which require elevation. So finally, we move to our last speaker of this session, Vrinda. The floor is yours. 15 minutes plus, if you like.
I'll try and keep it short. So it's great following after so many speakers, so many esteemed speakers. I'm not sure how much I have to add. I'll start off with this, Anita spoke about a very well-informed lawyer maybe understanding the idea of privacy policies and being able to opt out. So it's very interesting, but in 2018, a study was done by some researchers who asked law students, so these are, fifth-year undergraduate law students, to analyze the privacy policies of 5 companies. So you had your Paytm, Flipkart, Google, and 2 others, I think Amazon and Uber. And they asked them to just answer certain questions based on those privacy policies, just to test their understanding of the policy. And they found that the complicated terms used in those policies meant that many, even law students, were unable to actually understand the impact of the privacy policy. So what really happened with their data? How was that data shared? So this just gives you an idea of how complicated privacy policies can be. And there's another interesting idea in the literature which talks about control paradox. So for many users, just the fact that they read a company saying, we respect your privacy, means that they feel they are more in control over their privacy choices, regardless of the actual control that may or may not exist. So, just as an aside, sort of privacy policies and notice and consent, like the notice and consent framework has a lot of problems. And one of them is these overly complicated privacy policies. What I do want to speak to you, however, about today is the idea of maybe looking at data governance and more the focus on criminal law and the DPA bill. So the constitutional principle of a data protection law has been set out in the Puttaswamy judgment by the Supreme Court, the 9-judge bench, which reaffirmed the fundamental right to privacy. Justice Chandrachud had very clearly pointed out in his plurality opinion that the creation of such a regime requires a careful and sensitive balance between individual interests and legitimate concerns of the state. And I think if you look at some of the features of this new data protection bill, the tilt is clearly in the favor of central government and against maybe the interests of the rights and interests of individuals and the fundamental right to privacy. I think I want to really foreshadow my comments by first making it clear that regardless of the critique that I'm going to make of the bill, it is important that India passes a data protection law today. I think especially when you look at the expanding use, the ever expanding use of technology in law enforcement, whether it is the use of CCTV cameras, the use of facial recognition, emotion recognition tech, the criminal identification bill that everybody spoke about, or even the use of technology during the pandemic. So Arogya Setu, COVID data, the explosion of AI, all of this is happening without a data protection law in place. And there is a lot of literature about how the IT Act itself has various problems, and so it's very hard for individuals to seek any protection against the private corporations. So it's important in that context that we have a data protection law. But there are three broad problems, I think, when you look at the data protection law and vis-a-vis the relationship between a citizen and a state. So the first noticeable feature of the new DPB is that it's a questionable design choice by which they have decided to completely evade or avoid the question of surveillance reform. Now, surveillance reform was also consciously omitted in the 2018 version of the bill that Justice Sri Krishna Committee had released. But even then, the committee in its report had noted that no general law in India today authorizes non-consensual access to personal data or interception of personal communication. I mean, the simple idea is, what is the good use of a data protection law if it does not regulate any mass surveillance frameworks that we have today? The CCTNS system, which is the interface between the police and the individuals, the centralized monitoring system, NAT grid, all of these are existing. We have cases, all of the reporting around Pegasus. There was a real opportunity for this data protection law to also talk about surveillance reform, especially in a situation where all of our intelligence agencies lack any parliamentary or institutional accountability. So all your biggest intelligence agencies today that are collecting data or conducting surveillance aren't answerable to Parliament. There is no inter-branch oversight of surveillance institutions in India, something that even Justice Sri Krishna pointed out in his report, which is a real problem with our current surveillance framework. Given all this, I think it was essential that the data protection bill should have had some sort of chapter on surveillance reform. Instead, what the Data Protection Bill 2021 does is it makes things worse. One of the things that I found most people haven't sort of really, I think, spoken enough about, and maybe it's just a very small stylistic change, but I think it's very important. The preamble and the long title, especially the long title, has actually been changed and amended in the new JPC. I'm sure if you look at the long title, you'll see it. The change is that they have inserted the phrase to ensure the interest and security of the state in the long title of the bill. Now, this is a data protection law. The whole idea, it comes out from the Puttaswamy judgment. The whole idea was to protect individual privacy, right? The bill and the need for a law came out of the recognition that we need to protect right to privacy. What is the purpose? How can the purpose of a data protection bill be to ensure the interest and security of the state? It's very important. I mean, there's a lot of scholars like Neil Richards who have spoken out about the issue that it's important to have friction in law enforcement purposes because there is an asymmetric power balance between the state and a citizen. So if the citizens don't have procedural protections, if the citizens don't have rights, even if it means that law enforcement becomes a little more inefficient, that is okay, because that is a society that will then protect rights. So given this concern, I think this is a very interesting change by the JPC. And you also see this in the general tone and tenor of the bill, where the state is then given a lot more protection and a lot more exemptions rather than private companies have. Which is the second point that I want to speak about, which is the power of the central government to exempt various departments from its application under Clause 35 of the bill. It has been referenced by speakers, I think, since morning, but I think I want to go into it in some detail. Now, this provision was first introduced by the Sri Krishna Committee, but it has witnessed a considerable dilution from the 2018 version. The exemption clause in the original 2018 bill was tethered to the conditions of legality, necessity, proportionality, coming from Puttaswamy. One may argue that these requirements will exist automatically in any law, because the Supreme Court has made that clear. But we all know that when a law is implemented, it's important that the text also supports your implementation. I mean, you're seeing this in sedition cases, right? Kedarnath may have read down, this 124A to a certain provision, but the way it's used on a day-to-day basis is very different. So I think it's important that the law also reflects the text of Puttaswamy. And Puttaswamy is not just some principle that is superimposed. So this was diluted in 2019 when the PDP was introduced in Parliament. And the government said that they would be able to exempt the application of the entire law. So not even provisions which the 2018 version had protected, such as such as that yes, the government is allowed in the interest of national security to exempt the provisions of the bill, but it must ensure security of your data. So this is a simple, and it must ensure fair and reasonable processing of your data. What does this mean in practice? This simply means if the police is collecting your data, they should not leak that data, right? That data should be secure. You have a certain right and expectation against the state that your data that has been collected through the use of, say, lawful interception is not then passed on or is not leaked to other departments. It is actually protected, and that they're processing that data fairly. They're collecting only what is needed. They're not collecting last 10 years of your life to create this detailed profile. They're only, say, intercepting a limited period of your conversations. Even these minimal safeguards were exempt in the 2019 version, and this exemption continues in 2021. If the government is satisfied in the interest of necessity or expedience. So this is again important. When we think about just expedience, which means effectively convenience, is a ground for the government to say it is more convenient for me in the interest of national security, and now after 2019, also in the interest of friendly relations of foreign states, public order. Public order, as we know, is a very, very broad category. It is convenient for us to exempt the application of the entire act for a government department, and hence we are passing such an order. So Justice Sri Krishna actually called this exemption and the dilution of the exemption a dangerous trend. And he said, like in these very, I think, famously quoted upon remarks, that it will lead to an Orwellian state. So I think it's very important to remember what 35 can do. 35 effectively gives unbridled powers to the central government to exempt the government agency from the act. There is no requirement for the government to get any parliamentary approval for exempting any of its agencies. They just simply pass a notification. The reasons for this exemption are not recorded in writing. There is effectively no accountability and transparency. Instead of rectifying this provision, which was criticized heavily by civil society, the Data Protection Bill 2021 in fact cements it. First, it adds a non-obstante clause, if you see clause 35, which provides further primacy to this provision over other laws. It is unclear to me how, for instance, will 35 work with the RTI Act? Can I file an RTI and say, provide me a list of even just the number of cases in which you have granted an exemption? Who are the agencies who have been exempted? There's a sort of separate literature about a lot of the fight that has been happening in civil society to even simply get data from the government about the total number of surveillance requests that have been authorized under 69 of the IT Act in a 2-year period. Just aggregate data. Given this, what does it mean to have primacy in 35? The second change is that there was a clause has been added that stipulates that the procedure to be followed by the government agency must be just, fair, reasonable, and proportionate. But this change again is only applicable to the procedure and not to the substantive standard for the government's invocation of exemption. So to put it another way, the government doesn't need to establish that the exemption from the entire data protection bill is necessary or proportionate to achieving its purposes. It just needs to say that the procedure it has followed is necessary and proportionate. Now, there is no doubt that data protection rights may not apply in their totality when it comes to national security concerns, and I don't think anybody is really arguing that there cannot be any exemption. The question is how such exemption is worded. Is the exemption in the nature of an exception, or is it really becomes the rule? Is it limited? Is it targeted? So even in the UK, the Data Protection Act 2018, the national security exemption does not extend to the entire act. It requires a certificate that is signed by the Minister of Crown. It can be challenged by an affected person. But in India, as I've already mentioned, even the reasons for providing this exemption are not required to be tabled in Parliament. And in fact, I believe if you read Mr. Jairam Ramesh's dissent note, he actually said, I would have agreed with your, with your amendments to 35 if you had just said that let these reasons be tabled. But since there was no consensus, I dissent. There's like I've already mentioned, the order invoking the exemption is not a gazetted notification. It will likely be exempt from RTI. And hence, without any oversight, the government may be free to exempt its departments and ministries, from the data protection law in perpetuity. The second clause I want to talk about is 36. Although actually there's a lot of controversy around 35, I believe 36 is more insidious. Now, if you see how 36(1)(a) starts, it says that the provision of chapters 2 to 7, which is most of the data protection principles that have been spoken about, except 24, which is security, shall not apply where the personal data is processed in the interest of prevention, detection, investigation, prosecution of any offense, or contravention of any law for the time being in force. Now, unlike every other clause, including 35, 36 is not limited in its applicability to the state. To put it another way, any private person or RWA, and we all see kind of surveillance by the RWAs, the MyGate apps, technically, any person can seek this exemption. The exemption is not limited in only the government being able to seek it. So I think if you look at the, just the language of 35 and 36, I'm just trying to take out, 35. If you look at the language, 35 says the power of the central government to exempt an agency, whereas 36 starts by saying, the personal data that is processed, the provisions of this act will not apply. So I think it's very important as to who can invoke the exemption under 36, and it's something that hasn't been discussed in what this means. Second, it talks about any law. So, any minor contraventions, non-criminal offenses, civil law remedies, all of that becomes a reason to be able to seek this exemption. Third, there's no requirement that this processing of data is proportionate or necessary as per the Puttaswamy standard. Fourth, there's no requirement of prior judicial review for invoking this exemption. All of which makes, according to me, 36 actually far more dangerous in how we will as normal citizens interact with it. It is something that will actually touch it. The exemption will be used much more against us in our daily lives. The third and final feature, because I know I'm short of time, so I'll just take 2 minutes, is that the Data Protection Bill concerns the constitution of the Data Protection Authority. The Data Protection Authority, under the version of the bill and the idea of the bill, is really the be-all, end-all, the powerful entity. It is tasked with ensuring compliance with every aspect of the law, and it is also tasked with being in consultation with the central government to come out with various policies. There's a side issue about the fact that the bill only allows the DPA to have a chairman and 6 whole-time members only, which, and right now, we don't know if it will be there in different states, whether there'll be other DPAs or there's only one DPA in Delhi. But that becomes important when you want to see that the act, for it to be effective, can't be situated only in Delhi with 6 members. You need to have DPAs at various state levels. You need to have a big DPA. Like in other states, other countries, a DPA is a whole department of itself. It can't just have 6 whole-time members and some part-time members. But apart from that, under the 2018 version, Justice Sri Krishna had proposed the appointment committee of the DPA to consist of judicial members, with the Chief Justice of India as the chairperson to choose members of the DPA. This was watered down in 2019, and the panel included the Cabinet Secretary, the Law Secretary, and the IT Secretary. So no independent oversight in terms of the appointment process. This was heavily criticized. So there were changes that were made in Clause 42 of the Data Protection Bill, which says that the AG, the Attorney General, as an expert, the Director of an IIT, and the Director of an IIM are included in the selection panel. I don't think this goes to completely address the problem of the center having a far-sized influential role in appointing the nominees. especially because there is also a lot of freedom in deciding which director you choose from which IIT or which IIM. So I think it's important that we set up a more independent panel to constitute the DPA. So in the UK, for instance, the Data Protection Act, the Information Commissioner is supposed to be appointed on the basis of a fair and open competition. Why is that not something that we are even contemplating in the Indian experience? I think I'm sort of short of time, so I'm going to end my comments. But I think what I wanted to just note, these two, Justice Jairam Ramesh again in his dissent, made this very interesting remark that government agencies are treated as a separate privileged class whose operation and activities are always in public interest and individual privacy considerations have become secondary. And I think this is true and brings back to mind, the wry writ of Yes Minister, which is that the Official Secret Act is not to protect secrets, but it's to protect officials. And so I think the only hope is that one can talk about these ideas in strengthening the data protection law when it comes into force. Thank you.
Thank you very much, Vrinda, for that excellent analysis of the statute and the mechanics of it and how it's going to sort of play out in the future. It gives us some kind of insight into it. I had quoted from Gopal Krishna Gandhi's Tirukural this morning, and I have another verse maybe to bring down at least this session. He says, and I quote, "The minister who relies on plans and lofty schemes alone, but forgets the ground, stumbles on reality's stone." So we have to hope that Parliament doesn't sort of stumble on reality's stone. There's lots of problems, there are lots of challenges. We heard about even what we considered, or what I considered, the gold standard in terms of the GDPR having its limitations when it comes to addressing community rights and aspects like that. So this has been a truly enlightening and wonderful session. I thank all the panelists for their time and their contributions, and I request all of you to show your approval of the outstanding presentations in the usual manner. Thank you very much. Thank you. Thank you. Thank you, Rajiv. Yeah, sure. Oops. Sorry. No. Okay. Thank you. Thank you very much. Thank you. Oh, all right. Thank you.
Thank you, everyone. I would request Mr. Divan to please continue on the dais.
Okay.
And I would now request our President, Mr. Prashant Kumar, to join Mr. Divan on the dais. We come to the last session, which is the concluding session. But instead of having a panel of speakers, it would be good to have an open house. And I would also request our Vice President, Mr. Yakesh Anand, to join us here.
With your permission, if we can start the last session, which we are trying to invite participation from the floor. But before that, just a few thoughts which are linked with the presentations, and also some of the aspects which are more crucial to the legal profession, from not just the bill, but this whole context of surveillance, state surveillance being kept out of the purview of the bill, and at the same time the tension, or I will call it rather riding roughshod over a very central concept. We are talking about data fiduciary, but there is a traditional fiduciary relationship that is of a lawyer and client. So lawyer-client confidentiality and this has expanded and exploded on the global scale. Not the confidentiality, but the encroachment on it. In terms of tax evasion, in terms of money laundering, in terms of international exchange of financial information, and the general tools of surveillance, including taking the devices of any accused by the agencies. Now those devices have messages, those devices have emails, lot of them may contain consultation with the lawyers as well. As per law, they are supposed to be privileged and confidential communications. Now, when the whole trove of information, all the hard disk, all the devices, personal devices, are taken away, cloned and mined, then what happens to this? What when somebody is just clarifying something with a lawyer, that this is the law, this is the thing, how I have to go about it, this is the infraction which might have been done. And yesterday only in live law, we had the report that a lawyer who is representing a client has been sent a summon by police to appear, that what advice you are giving and with what motivation. So this approach of keeping the surveillance out of the data protection bill and the implication for the entire justice system and rule of law is so challenging and so fraught that once they get a legal framework around it where center can exempt so many agencies and all, something which is happening under the cover randomly may become a norm, and the authorities will feel legitimized that we can undertake all these actions. These are all now within our powers, because something which otherwise, what is an evidence, what is a tainted evidence, all these legal definitions, they collapse. So there are very, very fundamental questions for the legal profession, for the judicial system, and for the rule of law itself, which are going to span out from the basic design of this legislation if it is not implemented for protecting the rights, but it is implemented for empowering the authorities. Because right now, as the speakers have, previous speakers have spoken, that the journey from 2019 Shri Krishna draft to the latest draft is to empower the government rather than to protect the citizens. So that is a very big danger lurking behind it. Another thing which is important is that yes, we can talk about big companies and all the businesses adopting privacy policies just not to bear the burnt of its fallout and to tick boxes. But if implemented seriously, it also can benefit a business in terms of reducing its legal expenses and other time consumed in getting into unnecessary disputes. And that is where, I will use the phrase borrow the phrase from Shyam, lo bono. So I advise one of the prominent digital media platforms, and there we are actually implementing the concepts. Like, there is a news about a matrimonial, domestic violence or something which are more individual issues. They come as a news, but in digital world, they stay put for the longest time. They are never erased. So as a matter of policy, whenever any request comes that this is the case, we have gone in appeal and all, we examine it and we advise that this be taken off, because it is no longer serving a public person, rather than maybe it is an impediment for the parties to reconcile. So the same thing about the cases in campus, because all these things linger on. So I can tell you, though it is personally for me has become a low bono enterprise, but my client has zero litigation for past 2 years. A digital media platform which is not very pro-establishment has zero litigation, no defamation case, no other case. So that is how a proper implementation of policies and an approach which you take to implement these concepts in letter and spirit can sustain businesses much better. But on the other hand, we are seeking more trends for transparency and other things in judicial system. And we are watching nowadays like a soap opera, the YouTube recordings, because the timing doesn't suit of Johnny Depp Amber Heard defamation trial. And there each witness comes and gives a full detail. I live here, my address is this, I worked here and this thing. So all this information through trial and all the questions are coming in private domain, not just of these two people, individuals who are contesting against each other, who have chosen to record their private movements, which are also being put in public domain, but also the reactions and what other people were doing at that time. So that kind of, a theatrical exposition of a court proceeding, though we are also demanding that, court proceedings should be telecast live, but what are the perils of, telecasting? The better soap opera is parliament and assemblies. I think we should leave the courts out. So these were a few comments, and I think, as a profession, we have to be alive and rise to these challenges, and they are going to multiply as this law becomes, as this bill becomes a law, and these challenges are certainly going to confront us. So now I think, as we said, that we want to utilize this session more for the purpose of inviting, participation from the floor.
Before we take the formal questions or participation from the floor, last comments from Mr. Divan, please.
I didn't have any particular comment to make, except if I might just respond to some of the points which President Prashant Kumar raised a short while ago. I share the concerns which he expressed, for example, in terms of this rather indiscriminate taking over or attachment or confiscation of devices. And almost everyone over here, I'm sure in this room, has some such device which contains a large amount of material. And this privilege which he spoke about in terms of communication to lawyers is an extremely important and ancient privilege which we should try and to the best of our endeavors as members of bar associations and individuals protect. Because at stake is liberty not just of the individual whose phone is seized, but is liberty of individual, the client in the first place, the larger community. And I think what a theme which came across in many of the presentations made through the day was on how these enormous changes and strides in technology, willy-nilly, and there's no putting the, stopping the clock on this, is really altering the relationship between the citizen and the state. Now this is kind of inevitable. The citizen and the state relationship is going to alter. The point I wish to project is that there are some abiding values, we can call them the preambular values of our constitution: liberty, fraternity, equality, And does this mass of data available in the hands of large corporates and available in the hands of state and even available in the hands of others perhaps distort our endeavor to preserve, protect and expand these absolutely basic and essential values? Because I think we lose a lot if in focusing on the current problem or the immediate issue, we find that we are compromising and eroding this much larger value. So I see moving forward with, of course, the bill probably taking shape of an act. I see huge number of contestations. I don't think there's any escape from that. That's the way our court systems and our protection of liberty evolves and functions. But I do also see a need for, I think, 3 or 4 things. The first is a persuasion within society itself, not just individuals, but a realization that what's at stake here is not just, the identity theft, which, for example, Uday spoke about, where his client suddenly found that someone was using maybe an Aadhaar card in some distant place and impersonating him, etc. But I think what's at stake is that with these huge powers over data that the state can wield or organs of the state can wield, they are going to be able to possibly manipulate us as a citizenry, or as communities, in manners which we can scarce imagine. And it therefore becomes very, very important to stake out grounds, to just not preserve, to first recognize the value, secondly to stake out grounds where we say that look, so far and no further, and therefore the whole test in terms of proportionality, you can take information and data only for that stated and limited purpose, you must preserve it, you ought not to share it. Because if we allow, and I think it came out again in presentations, the CCTV camera and then facial recognition and then, even greater advances in terms of what your emotions are and what you're thinking about on the basis of algorithms, it becomes a very, very dangerous path to follow down. And I think at the end of the day, we will be imperiling those core constitutional values that we have. So this session, and I really thank the organizers. Anindita, of course, has put in huge effort, and all the others as well, in bringing this session together. But I think what's at stake is just not the bill and the act, but really foundational values of our society, which unless we realize and rise to the occasion, might suddenly erode. So thank you very much.
Thank you, Mr. Divan. Now it's open for discussion. We can perhaps have discussion for next 10 to 15 minutes and then we close the session. There is a mic available if anybody wants to say something.
It's been quite an exhausting. I think we can close it.
I think we are all, we have taken in a lot of information and it's time to process them perhaps. So now I request our Vice President, Mr. Yakesh Anand, to kindly give the vote of thanks.
Friends, I am here to just put an end to today's session after long deliberations. Proposed vote of thanks. Good evening to all. Eid Mubarak, Akshaya Tritiya greetings to all. Both the festivals are most auspicious. Prashant, President Bar Association of India and former President Law Asia. Mr. Shyam Divan, Vice President Bar Association of India. Dr. Anindita Pujari. All members of the Executive Committee and Governing Council of Bar Association of India. Other members of Bar Association of India, fellow lawyers, law students, media personnel, ladies and gentlemen. It gives me immense pleasure to deliver the vote of thanks for this event organized by the association. This is the first event after 2 years because of the COVID-19. I would like to thank Justice Indira Banerjee, Judge Supreme Court of India, who presided as a chief guest today, for her inspirational thoughts. I want to thank all the speakers for sharing their views and thoughts on the proposed bill, Law of Privacy and on Personal Protection Bill. This will be the first time that in India we will have a regulatory mechanism which will come in some form or the other, whether the old bill, the revised bill or the new bill. We all have experienced the past misuse of social media, whether it's defamation, cyberbullying, impersonation and identity theft. We all have suffered that. There have been occasions when my daughter's Facebook account got hacked. We've lodged complaints. There was no way we could get a remedy. We had to close down the account. I've experienced personally when I use my card somewhere in India and after 2 hours I realize X amount of money disappears from my account. Somebody had my credit card numbers, and how it happened, the banks were unable to give it any answer. We had issued notices and matters pending. Friends, today I want to acknowledge the presence of all office bearers of our association who are presently here and who had contributed today for today's session. I acknowledge the presence of Mr. Chander Uday Singh, Ms. Ajankia Sharma, Dr. Pinky Anand, Mr. Rajiv Duta, Mr. Mohan V. Katakari, Mr. Maratha, Mr. Dashanand Gaur, Mr. Ajankia, Dr. Akash Kaushik, Puneet Sharma, Mukesh Singh, Uday Warunjikar, Apurva Sharma, and many others. I want to thank the team of Live Law to cover this seminar. Special thanks to Prashant, Shyam, and Anindita, and to Mr. S.D. Sharma, Subodh, and Roshan. Thank you very much for being here with us today.
Thank you, Mr. Anand. I think there are a few more names that I would like to mention. First and foremost, I would like to thank Mr. Divan and his office and Ria, who is here, for actually initiating the process of having this seminar. So thank you for suggesting such a wonderful topic which was received so well by the audience. Thanks to our media partner Live Law. Parvati is still with us. Thanks to you. There are 2 rapporteurs that we have, and I must mention their names. We have Anubhav and Ria with us, those who have been rapporteuring for this event. We have Mr. Yakesh Anand and Kajal Chandra ma'am, those who helped us organize and book the venue and help us with the entire organizational aspect of the event. So thanks are also due to you. Our volunteers, Prakriti, Siddharth, those who have been helping us for the past so many days in organizing the event. And of course, the biggest round of applause has to go to the BAI office led by Mr. Sharma, Subodh, and Roshan. Thanks to everyone. With that, we can conclude the session. Thank you.
On the other side, I didn't want to commit any of them. I've been advising one of the agencies. It's the group you said from the agency.
All are requested to kindly proceed for tea, and before you leave, you must enjoy your tea and coffee and then leave. Thank you.